Well, here we are, and we're winding down in 2023. Really kind of hard to imagine how time has flown by, and what a year. So much has happened. The economy, we started the year, we had it in one direction, and now at the end of the year, it looks like we're heading in a whole different direction. And entrepreneurship continues to flourish, and that's why every week we like to check in with Mark Furman, director and shareholder at the law firm of Tarlow, Hart Rodgers, for the important segment, Entrepreneurship and the Law. Welcome back, Mark.
Thank you, Jeffrey. Nice to see you again.
You too. And Mark, you always get the longest introduction.
Well, I appreciate that. So I was hoping we could talk a little bit today about unhappy co-ownership.
Make a living on it.
So, people have partners, business partners, whether they're shareholders in a corporation or members of a LLC or just regular old partnerships. And, people don't always take the time and incur the expense at the beginning to create formal agreements that will conduct their affairs. But there are also agreements that may have made sense at the time they were done in 1982, but 40 something years later, they make no sense, so that the agreement no longer fits the situation. So problems come up when there are disagreements, as one might expect. And the question gets raised, how do you resolve disagreements? And what if you have no operating agreement or shareholder agreement? And what if you do, and it never speaks to how to decide a disagreement? Right. So sadly, those cases are more common than one might think. And each of us have, in our professional careers, spend a lot of time working through issues in companies where there's conflict among the partners. I'm using the partners to, generally among the co-owners. And, just some of the issues that people can have disagreements about are compensation. You may have somebody who's killing it in terms of moving the company forward, and other partners have maybe taken a step back. They may be at different stages of life. Their contributions may be vastly different. If there's no agreement among the partners, how do you decide? How do you get to a decision point that hopefully doesn't involve litigation? Is there a mechanism in the agreements to resolve disputes? Is there a arbitration provision? Is there a mediation provision? How do you go about resolving it? And what if it's a 50-50 arrangement? Two partners, they each own 50%. Lawyers are not big fans of these kinds of arrangement, and they completely disagree on something. So effectively, they each have a veto right, unless there's some mechanism within the agreement that says, if in the event of a deadlock, this is how we're going to break it. And you want to break the deadlock without killing the golden goose. You don't want to dissolve the company and kill the company. You want somebody to buy out somebody else, or you want to have a third party break the tie. And so the company can make a decision and move forward. But what if you don't have even an ownership agreement that speaks at all? Well, the state has written some agreements among the co-owners, but it's not comprehensive, and it's not individualized. Just like the state has written a will for you if you don't make a will. It may not be your wishes, but the state's written a default will if you die intestate, that is, without a will. And what about the legal duties of co-owners? And let me speak to those a little.
Yeah, that's interesting.
Unless, if I'm talking about closely held businesses, just few owners, let's say it's a Massachusetts company, and there's no shareholder agreement or operating agreement. Under Massachusetts law, they're treated as partners, which means that they each owe a fiduciary duty to each other. They also owe a fiduciary duty to act in the best interests of the corporation. But Massachusetts, consistent with partnership law, the co-owners owe a fiduciary duty to each other. In a shareholder agreement or an operating agreement, the parties can agree that there are no fiduciary duties. And I do see that all the time. But frequently, that's not in an operating agreement. And therefore, the duties, the fiduciary duties, can exist unless there's some very specific agreement about something. Let's say the co-ownership agreement says under each person who owns, no matter what, will receive $100,000 of compensation and not a penny more. Well, if one person thinks they're entitled to 100, it's not a breach. More than 100, it's not a breach of fiduciary duty because it's specifically covered. But if it's not specifically covered, then the fiduciary duties live. Even if fiduciary duties are eliminated in an agreement, there is always an obligation of good faith and fair dealing in connection with any agreement. People have to act so as not to deprive the other parties of the benefits of the agreement. So this also comes up when you get to retirement, buyouts, mandatory buyouts versus discretionary buyouts. You have people who get stuck owning an interest in companies that they can't, they're not working anymore, and they can't get any return for their investment. What if the managing shareholders want to keep investing profits in the growth of the company, and the retiring shareholder wants to get some return on his or her investment, even though they're no longer working in the company? There's so many issues that come up in closely held businesses when the partners have a different view of the world. When everything is rosy, when everybody has the same vision, when everybody's making an equal contribution, there's a tendency to just let the good times keep rolling. But when there's a problem and the vision is different, circumstances are different, that's the time people look at what the agreement says. And if you don't have one, or it's got so much dust on it because it's 40 years old, it may very well not fit the situation. And that's what leads, in many cases, to very difficult disputes, which are quite expensive, and they can damage the company.
I'm only going to add one to your very extensive list, and I've seen all the scenarios you've said, and it could be a problem. And let's say it's a family business, functions very well within the family. And there's an operating agreement that sort of deals with everything and the structure and maybe a board or whatever. But then you have the next generation, and you need to revise the operating agreement for the next generation. There could be less people, more people, different skills, different contributions in the next generation. So I do think all those things there has to be a life to them. Maybe you're going to tell me I'm wrong. They have to evolve over time, just like people and their lives do. You have to always adapt.
That's right. I mean, take the example of, siblings start a company, and when they start it, they have little kids, and those kids become adults, and some want to be in the business, and others want to do something else. What happens? What happens in the event of death? Do you want a surviving spouse to become the 50% owner, whatever the percentage is? You signed up to be partners with your siblings. Did you sign up to be partners with your sibling's wife or husband or children? What
Right.
if you don't have the same confidence in the next generation that you had in your sibling? What if you want to sell and they don't? What if you want to pursue a particular growth area and another co-owner doesn't want to? There's so many issues. I mean, you could go on forever about all the various things people can think differently about.
I said to a father yesterday, yeah, if you wanted to make a decision, the family, you might have been participative, but if you made a final decision, the family all agreed upon it. I said, in the next generation, that's not going to happen. Everybody's going to think it's a democracy, one person, one vote. I go, you're going to have stalemates all over the place. You need to have an operating agreement. And the father was like, I hadn't thought about that. And I was like, yes, we need to look at everything and revise everything. Mark, I think it's a very relevant topic. Businesses need to be run properly. I think a lot of people in this country wish that we had more. They look at the Constitution. They always go, let's reform government to be more relevant today than what it was when we created the country. And we're trying to work, from an older system. So even governments have to, I think, update themselves. And we try to do that as much as possible.
We've had amendments.
Yes, we've had
amendments. They don't come easy, amending the Constitution.
So if somebody needs to amend their Constitution, look at their Constitution operating agreement, how do people find you, Mark Furman?
I can be reached at mfurman, Furman, at TBHR-law.com.
That's wonderful. And you can find Mark every week on Radio Entrepreneurs.